This is The Law Show on CL 650. Now back to the show.
Lawyers in Love, Jackson Brown, right? I got her. All right, good one.
Don't remember that one.
And Lawyers in Love,
Fortunately.
I think could be 70s. That's going back a while. Yeah, we're talking about a state law. We have our experts here, John White and Peter Lightbody from LakesWhyteLLP in North Vancouver. And we've talked a lot about WESA, when you can apply to have a will varied, who's able to apply. So basically you have a spouse or children. And we talked before the break about what defines a spouse, a common law, all those sorts of things. Now, children. You would think that's pretty cut and dry, but there's some gray area there too, right? We talked a little bit about having a foster child, and they're not legally your child. They are not able to come forth to have a will varied. You need to have a legal avenue.
Well, that's right. I mean, we talked about who children are earlier, but it comes down to this. If you're going to have standing to apply to vary a will under WESA, you need to be, if you're a child of the deceased, you've got to be either the natural child of the deceased, or you have to be the adopted child of the deceased. So you gave the example before the break about a foster child who had been raised from an egg, but nevertheless hadn't been lawfully adopted, and that person wouldn't have standing to apply to vary a will. As Peter pointed out, there might be some other remedies that might apply, but not this one.
So can you... I've heard this, sort of a layperson. You can't disinherit your children from your will. You can't say like I've got 3 children. I got Bob, Sally, and Mary, and I'm leaving Bob out because he's a no good. He never came around. He never came to see me. I haven't seen him in 30 years, so he's done.
Oh, there aren't many absolutes like that in wills variation legislation. I wouldn't agree that you can't disinherit your children. There have been cases where children have been disinherited, and the court has upheld the disinheritance. I'll give you an example. There was a case that came out about 20 years ago where the son became belligerent towards his parents, and he actually punches his father out.
Nice.
And he then leaves and never has any contact with his parents again. And he was disinherited in the will, and the court found that whatever moral duty the parents, or the father in this case, had for disinheriting the son was negated by the fact that the son had conducted himself in that fashion. When we're talking about disinheriting or not disinheriting children, we're looking at 2 different things. The leading decision on wills variation countrywide is a case called Tatarin, which is now over 20 years old. But it talks about a will maker's legal duty to spouses and children, and the will maker's moral duty towards spouses and children. With the legal duty aspect, typically if the children are underage, there's going to be a legal duty. If the children are adults, there isn't going to be much of a legal duty. When we're talking about disinheriting or not disinheriting adult children, we're talking mainly about moral duty. And in the punching out case, the court found that whatever moral duty the parents owed to the kid who punched out dad and then left, that moral duty was negated by the son's
his actions.
Contact.
No, I just want to ask a question. You've got three children again, and the one daughter is there every night, bringing the elderly mother or father dinner, takes them to their appointments, goes grocery shopping for them, comes around and mows their lawn, gets the repairman in to fix the roof, and does all of that. And you've got the 2 other children who do nothing. Now, it could just be geographically because the other sister lives in Halifax, but then there's the Bob who does nothing. He hasn't been around for years.
And what does the will say?
And so the will says that the daughter that looks after her gets the majority of it, and the other 2, say we'll do 80 and 10 and 10. Would that be upheld if the other 2 children come forward and say, well, why does she get 80% of the estate? We're entitled to more than 10%. Can they argue that successfully if she did all the work for the mother?
Well, those are nice facts,
You like those?
Yeah.
Because you have a good argument for her, right?
Yeah, I'd prefer to be acting for her, of course, but well, maybe not. That puts you right into the zone of you know, what is probably reasonable for that will maker.
But then you could say, well, the one daughter lives in Halifax. She couldn't possibly be there to take the mother to the appointments and look after her house and those sorts of
Well, so that if people are being excluded from a will, and our Court of Appeal has confirmed this, so the reasons must be valid and rational. And so, you know, to be valid, it has to be based on facts that are true. And to be rational, you have to be able to connect those true facts to what's in the will. And so,
in this case,
all kinds of facts come into play here.
Right,
and
right.
if there's a geographical factor for one of the kids who can't look after mom in the same way, that may not be rational. You know, it may not even be valid. But the court's still going to have to pay some respect to what we call testator autonomy. And so this is the tension in all of these cases. The court would like to respect what the will maker wanted to do, but the court would also, you know, like to respect that the daughter who was in Halifax shouldn't be punished. So I think, you know, without knowing more facts, it's tough to say.
I'll
but
make more
I think,
up if you like.
Yeah, well, I expect the court would vary that will
to some degree,
unless there was a very good reason for the two to have only 10%.
All right.
Yeah.
Now there's obviously an executor involved in all of this.
Right.
So in our last couple of minutes, what's the role of the executor when it comes to varying a will?
Neutrality.
They're the neutral body.
They have to be the neutral body. They're not the referee. They are simply,
that's the court's job.
That's
to be the
court's job.
Right.
In a wills variation proceeding, the executor is required to be neutral and really only comes to court, or really only should come to court, in his or her capacity as an executor, simply to tell the court, look, here's what's in the estate, and here's what the will says. And it's up to the beneficiaries and their counsel to fight it out as to whether the will should be varied or not. But the executor is not expected to take a position in their capacity as executor.
So you're more free advice here to anybody who's listening who's an executor of an estate and you're going through this process, is that you want us to just play it right down the middle.
Play it right down
But
the
a
middle.
lot of times these are family members that are executors, right? So they're an uncle or a cousin.
Well, yeah, you know, oftentimes they're all executors of people who want to challenge a will. I mean, that doesn't happen that frequently, but it does happen. And if you're an executor, you want to challenge the will, you have to step down
That's
as
else
executor. Yeah, because you know, there's a rule that says you can't sue yourself effectively. But neutrality is generally the name of the game. Yeah.
Well, it's been an interesting discussion. It's gone by very, very quickly. We've been talking about estate law and WESA. And tell us quickly what WESA stands for again.
The Wills, Estates, and Succession Act. This is British Columbia legislation.
All right. So if you have any other questions, these two would be happy to answer them if you're in this situation over at LakesWhyteLLP in North Vancouver. We're speaking with John White and Peter Lightbody. Thanks, both of you, for coming in. It's been an interesting conversation, and we'll pick it up next time on The Law Show on CL 650.